The Supreme Judicial Court of Massachusetts recently decided upon a ruling that could change the outcome of hundreds of OUI cases in Massachusetts. Yet one local lawyer says the facts surrounding what types of cases would be affected seem to be a bit confusing.
There's a lot of information out there about the machine itself being ruled as unreliable, etc., etc. And that's just not accurate.
After reviewing a number of OUI cases, the court held a hearing on the reliability of the alcohol breath test machine, the Alco-Test 9510, commonly used in traffic stops across Massachusetts.
The challenge was to both the reliability of the machine as to its source codes, as to its testing, as to its science, as to its procedures, and then to the Massachusetts State Police Lab, their testing unit, and the procedures that are followed to calibrate and test the machines.
Jabb says that in reviewing the machine, the Commonwealth found that the machine itself was reliable after meticulously reviewing its source codes, logarithms, and science behind the technology. Yet the testing and calibration procedures used by the Massachusetts State Police Office of Alcohol Testing, known as OAT, were found to be unreliable in an astounding number of cases.
They found over 432 separate times that machines failed calibration, and this information was not disclosed to defendants. Now, these are annual certifications, which means that if you have 435 annual certifications that were failed, that's a lot of breathalyzers that weren't properly calibrated over a time period.
Despite the findings, Jabb says that the situations in which this ruling would mean an overturned case are very specific.
It's limited in time from June of 2011 till September of 2014. They won't challenge all cases, except those involving manslaughter with an OUI, serious bodily harm with an OUI, or a fifth conviction. But if your conviction was not based on the breathalyzer, but rather you're drunk driving and you're crossing and swerving the road, and somebody testifies that you had 10 drinks, etc., etc., and the conviction is really, in essence, based on testimony or other evidence, then your ability to reverse that case significantly declines.
For clients where it may have been their first conviction, Jabb says it is especially important to speak up.
It's never the first OUI that creates the problem, but when you get a second and third OUI, there's impositions of criminal time. You can spend time in jail. You could have your license taken away for long periods of time. My best advice is that if you were convicted during that time period from June of 2011 till September of 2014 of an OUI, and part of that evidence was a breathalyzer test, okay, I would consult an attorney as to what your rights are, and I would do so relatively soon.